Hello. The guest today is John Mills, JD, 2008. He is the founder of a law firm that works on death penalty cases. So, hi, John. What does your law firm do?
Hi, Tony. Hey, it's great to be here. I really appreciate you and your enthusiasm for Cornell. So, as you said, I'm an attorney at Phillips Black Inc. It's a law firm that represents people on death row across the country in post-conviction cases, which just means it's the first opportunity for them to present new evidence about why their sentence of death is unconstitutional for one reason or another. We do that in state and federal courts, and I have had clients in over 30 states by now.
Wow. So it's like a national law firm, has all over
Yes,
the country.
yes. And the
And
focus is on extreme punishments broadly. We have clients who were sentenced to 160 years for a first offense, which they committed as a 15-year-old. We've had clients who are sentenced to death for crimes they committed as 18-year-old, and we've had everything in between. But the through line, really, for our cases is trying to insist on the dignity of each of our clients and recognition that they're a person of value. And whether that means a focus on their innocence, that is obviously top of mind, but it can also just mean emphasizing that they're a person who is someone's son or daughter, brother or sister, and worthy of love.
gotcha. Like, how different are the cases from each other usually? Like, are there like different evidence you would present for each one? Are there different arguments?
Yeah, they can be as different as each one of our clients. So sometimes we have cases such as Richard Glossop's, where we have really strong claims related to state misconduct and the person's innocent. And so that will become the emphasis in the case. In other instances, we'll have clients who, like Terry Pitchford, had a jury that was the subject of racial discrimination. The prosecutor in Mr. Pitchford's case excluded the black jurors simply because they were black, and so we focused on the racial discrimination in jury selection. And then we'll have cases that are more oriented towards questions about whether our client's worthy of mercy despite having committed a terrible offense. And a common question in any death penalty case is whether a person is eligible for the death penalty based on an intellectual developmental disability. And so we've had a lot of cases surrounding questions like that.
So
And
these are
really,
on the federal level, so they all follow the same like case law usually.
well, so we get into cases most commonly at one of 2 points. Often it'll be in state post-conviction or state habeas corpus, which is the first time after the trial that you can introduce new evidence about the case. Or we often get into cases very late in the process, shortly before an execution date. And so when we're and in either instance, we will try to get into state court. But to answer your question about what law applies, there is quite a bit of federal constitutional law that the state courts are bound to follow. But we, of course, also try to find ways to obtain relief under state law wherever we can. And it can be an important source of rights that I think is maybe somewhat underappreciated by a lot of litigators, civil and criminal alike, that there's state constitutions too, and they're sources of individual rights that are important. And so, yes, we do look to the federal courts and federal constitution to try to protect our clients' rights, but we'll raise state law claims as well. For example, right now we're litigating a case in Arizona where our client was sentenced to life without the possibility of parole. Arizona has a constitutional provision that gives the governor the power to commute sentences except for treason or impeachment. That's not an unusual provision. What's unusual about this case, though, is the Arizona legislature has said that our client can't seek commutation of his sentence at all. And he's not
The
convicted of
legislature
impeachment.
said that?
Yeah, they passed a law
Oh
that
wow.
prevents. And so, I mean, it's not a complicated legal argument. The Constitution says the governor can commute sentences except for treason and impeachment. Our client's not convicted of impeachment or treason, so we think he ought to be able to seek commutation. So that's an example of a purely state law claim that we're pursuing for one of our clients.
Wow. So each case is very unique.
Yeah, and I think that's part of what is really fun about having a law practice that focuses on representation of individuals, is that each case is going to be as unique as your client.
So how do you like find the case, and is it each one like a couple months in duration or a couple years? Like what's the like average case like over the
Mhm.
life cycle?
Yeah, I mean, it can be quite different. We have joined cases where our client was soon to receive an execution warrant and only been involved in the case for less than a year, let's say, and did everything we could to prevent the execution from going forward. I've been in the case that I've been in the longest. I've represented a client for coming up on 16 years, and it's a case where we have some strong claims that he shouldn't be sentenced to death. And for whatever reason, the state courts have just been very slow to respond to our petition, and that works out okay in this particular case. And so we're not trying to push it, but these matters can be short, but if they're done correctly, they can also take a long time. Turning over every stone takes a lot of time and effort, and getting to real relief can also take quite a long time. Which is just to say, if let's assume we get them, a really great outcome and get our client's conviction and sentence completely set aside, and they get to go back. The remedy there is a new trial, and so it might be years and years later before a new trial is granted, which would just mean that a trial attorney is going to have to refamiliarize themselves with the entirety of the case, and that can take a long time too. So it can be a lengthy process. The outlier one for me is 15 years. More typical, I would say, is like 5 to 7 years in a state court representation, but it's a long commitment to take on a capital post conviction or
Mhm.
habeas case.
So like how do you decide which cases to take on, and
Ah,
the plaintiff, how does the plaintiff decide which lawyer to take on? Like how does the two
yeah.
sides decide?
So as an orientation for our practice, we kind of think about problem jurisdictions. So, for example, or really problematic cases. So, for example, we do a lot of work in Phoenix, Arizona. We have quite a number of clients on death row in Arizona. And Phoenix, for a long time, and was a county that was responsible for a huge portion of all death sentences nationwide. There's a ongoing phenomenon where death sentences are isolated to just a handful of counties nationwide. Less than 2% of the counties nationwide make up half of all death sentences. And Phoenix was a major contributor to that. Our clients, many of them were charged and convicted during a period in which the prosecutor in Phoenix sought death in over half of all homicide cases, which is just an insanely high proportion. That even the bench, the judges in Phoenix called that period the capital case crisis. And there's been a recognition that it was a crisis at the trial level. And we've been working for a number of years now to have the defense bar, as well as the judiciary, recognize that there's a current post-conviction crisis related to the cases that were tried at the time. That in the same way that there was a shortage of qualified counsel to handle the cases at trial, a shortage of resources from the bench to supervise the cases, and so on at the time of trial, that's now having downstream effects. And so Phoenix has been a high priority jurisdiction for us because of the capital case crisis.
These are like systematic problems then. It's like the system.
Yeah, and I mean, we do try to focus on places, right, that do have some systematic issues. I mean, another one, I mentioned Richard Glossop's case before. His case was prosecuted by another 2% county, another county that is vastly overrepresented in terms of people on death row, and by an office with a long history of misconduct. And sure enough, misconduct has infected his case, and other cases in Oklahoma have been also set aside. Executions have been stopped in light of misconduct that has come to light related to that office's prosecution practices.
Well, like is this like how deep does it go? Like the problem is it just like one prosecutor, where is it like the whole system is like the judges as well,
Mm-hmm.
or is it like the whole jury pool, like whatever jury
Well,
you select would be an issue?
yeah,
Like how deep does
yeah.
the problem go?
Yeah, I mean, I think the problem, there's a deep problem and then there's a shallow but broad problem. I think the deep problem is that when you're willing to treat people horribly, then sometimes you're also willing to cut corners, and or can be blinded by your own sense of self-righteousness. I think despite having uncovered some serious misconduct in places that have supposedly progressive prosecutors, for example, it's hard for those places to say, yes, we made a mistake. Sending this person to face their death was a mistake, is a huge thing to have to admit. And can be difficult to do. And so I think the deep problem is a willingness to engage in cruelty as public policy. I think that the broader problem that produces, outlier sentencing practices is what part of your question was getting at, which is that there are individuals who have a lot of ambition and a lot of power, and that it's not even necessarily reflective of the politics of a particular place, but is just a reflection on a person's ability to corner the market on charging practices, for example, and can, left unchecked, run amok. So yeah, I do think of it as both a systemic problem that kind of runs deep and raises questions about even who we are as a society or as individuals, but then also as a more superficial problem of like individual personalities who can overreach and create cultures of misconduct and cruelty.
Well, like the judicial system, there's usually like a tension. You got the prosecutor, you also got the public defender. What is it like in the courtroom before you showed up?
Yeah, I mean, just by virtue of the fact that we do post-conviction work, at least from our client's perspective, something's not gone right at least a few times by the time we show up. They've been convicted and sentenced to death, and their case has been affirmed on appeal. But I mean, what exactly has gone wrong is different in every case. Fundamentally, there's been a lack of recognition of their worth as an individual. But where the breakdown in the process is very case specific. I mean, sometimes it is a failure to be transparent about the weaknesses in the state's case. The state has an obligation to turn over evidence that's helpful to the defense, and sometimes they don't always meet that obligation. Sometimes it's overworked public defenders, oftentimes that's the case, who by their own admission will say, look, we were overwhelmed by the capital case crisis and the charging practice of the prosecution, and we're just unable to do things that we wanted to do. Other times, mistakes, I mean, it's humans operating the system, right? And sometimes humans just make kind of silly mistakes. I've had, for an example, I had a case where the public defender got funding to have our clients brain scanned and then analyzed by a neurologist, among others. And they managed to get the brain scan, but never provided the scan to the specialist to have them look at it. So, and they realized they hadn't done that on the eve of trial and panicked, but didn't seek more time. And it was a very human mistake. I think, they were working on a lot of different issues. It was also a large number of people on the team who were working. So I think there was some just miscommunication about who was supposed to do it, but it was a mistake. And the brain scan showed some serious damage that could have affected our clients, thinking at the time of the offense, probably did. And, they thankfully testified that, hey, we dropped the ball, but it's humans involved in these systems and people make mistakes. And I think it's important for us to be able to recognize our own fallibility. And I think it can be hard to do that sometimes.
I'm trying to figure from the defendant's point of view, like, did they first have their public defender and then that didn't go well for trial? So then do they reach out to you, or like how do they?
Yeah,
like,
how do we end up in a
Yeah.
particular case? Yeah. So sometimes people do reach out to us. The most common way in which we end up with a case is by having some relationship, formal or informal, with the group that is responsible for appointing cases. So in different places, there will be a committee that is in charge of making sure that there is a group of qualified capital defense lawyers. And qualified to do trial work is different than being qualified to do appeals versus post-conviction and federal habeas. And so, different senior attorneys in my practice have relationships with and expertise in different areas, different locations. And so a lot of my practice is in California, where I live, or in Phoenix, Arizona. I also have had a couple of cases in Oklahoma, whereas another one of my co-founders does a lot of work in Pennsylvania. A third co-founder does a lot of work in Texas and Mississippi. And so we each have relationships with the Capital Defense Bar in those places. And when a case is moving from trial to appeal or appeal to post-conviction, it's those groups that'll often reach out to say, hey, do you have bandwidth to take this particular case? And that is the most common way in which we get cases. Occasionally, we'll know that we have some bandwidth in our caseload, and so we'll follow cases that are on direct appeal and reach out and say, hey, I think we're available and interested in taking this particular matter on. But it's always with the public defense authority or some equivalency that we end up with a particular case. I mean, one distortion in post-conviction and federal habeas representation broadly is that you're entitled by statute, not by the Constitution, but you're entitled to a lawyer if you're facing execution. And you may or may not get a lawyer if you're not facing execution. And so in the post-conviction space, most of the representation is of death sentenced clients. And that means that folks without a lawyer are facing complicated procedural issues and often lose, not because they don't have good constitutional claims, but simply they have not managed to jump through all of the hoops necessary to get those claims reviewed on the merits.
So like when the committee, they have a new case in front of them, like how do they decide like this law firm would be a good fit for that person? Like is it just based on bandwidth, or are there other criteria that makes it a good fit?
Well, it's different in different places. Some of these committees will say, okay, like who's next on the list? We called this person first last time. We're going to just go through our list. From our perspective, we want to make sure that our client is represented by someone who's culturally competent to do so. So, and if the lawyer who's sort of leading the charge in that case isn't that person, we want to make sure we bring in investigators, paralegals, or co-counsel who are. If I was representing someone from a rural part of Idaho, I wouldn't have a clue of like what that might have been like as a person to grow up. So I might want to, make sure we have somebody with a little bit more information about what that would be like on our defense team. And, same goes if the client grew up in a large city in Mexico. I also wouldn't have much sense of what that was like and would want to bring in culturally competent team members to help us make sure that we're not missing important issues and understanding who our client is. So, yes, bandwidth is a big question. There's some really mundane questions about like, who did we ask last? I think that a lot of the committees ask. But who it is that actually conducts the representation is an important question on its own, because having a strong understanding of our clients, a strong relationship of trust is important to being able to do the job.
As your law firm has been in like certain areas for longer, like Phoenix, Arizona for years now, like is it easier to build trust with the person because they are like, oh, you helped this other person who I knew before? Like, does advantage grow over time? Like
Absolutely. Yes, it does over time. I mean, I'll, remember one of my first client meetings out of law school. I was in my mid-20s at the time, and my client looked at me and said, like, you're representing me? How many years of experience do you have? How long have you been doing this? Why are you here? All valid questions, but having developed some experience and some reputation within any area, any geographic area, certainly has helped. And the handful of successes we've had have always end up with folks reaching out to us from within the same prison complexes where we've had those successes. So we'll get letters from clients family members asking us to help them out after they've heard about us through other clients or wins in other clients' cases.
Mm-hmm. So the reputation is that you care about the client, that you listen to them well. Like, is that the
I hope that's it. Yeah, I mean, I at core, our job is to represent the interest of our client and their interest in being seen as an individual and to be heard. And I think that almost to a person, if our clients had that earlier in their lives, perhaps much earlier in their lives, they would never become our client. And so we spend a lot of time thinking about how to best relate with our clients and how to hear out their concerns and try to protect them and to raise up their dignity in any case. And and so I hope that's part of our reputation. I hope we also have a reputation for doing high quality work in really challenging spaces. We've had some fortunate wins over the years, and I've come to think about those less in terms of like we had a really brilliant idea and more of like we kept fighting long enough for things to shift. We've litigated issues that other people have long ago identified, but finally the courts came around to our side, and we happen to be the ones standing there to receive the nice opinion, when the courts have come around to our side. I've had another case where it was long suspected that the prosecutor's office in question had a policy of excluding Black potential jurors and Jewish potential jurors. There had even been a big evidentiary hearing about this decades ago. We happened to be still representing our client when handwritten notes from that office were finally disclosed after a progressive prosecutor had been elected and told to go back and look at the jury selection notes. And so that client is not only no longer on death row, but no longer has any convictions and is facing
Wow.
retrial not because of anything necessarily that we did, but because we were continuing to advocate for him and trying to do our best to make some luck here and there for him, and it fortunately worked out.
Like each case, like do you see it as like more standalone, or do cases like change like the system over time as well, like with more case
Mm-hmm.
law impact the whole
Mm-hmm.
system?
Yeah. Well, I mean, seeing it from my client's perspective, I always want to win on the narrowest ground possible because courts are small c conservative institutions. They like to move slowly and carefully and deliberately. And so finding issues that apply to one person only and are unlikely to result in sweeping change is a good legal strategy, really, in any context. That being said, those issues aren't always available, or sometimes getting the court to consider an issue requires raising some other broader question. And so and from my own perspective, if my goal is to help build a society that treats people with more respect and care, just winning a case where somebody has been deemed by society as exterminable, as trash, as not worthy to live another day, forcing that same system to say, actually, yeah, they are worthy of some mercy. Maybe they aren't even guilty of what we said they did in the first place. When even small wins on that front, I think, are an important part of bringing about systemic change. For a common critique of the capital defense bar is that there's too much time and resources put into death penalty cases when there are so many other extreme sentences out there, and there's an order of magnitude more people serving life without parole than facing execution in the United States. So that's a fair point. But my hope is that by forcing our society to see the human worth of every individual, including those who've been deemed the least worthy, we can open our eyes to the cruelty that we're perpetrating against many, many more people. And I think we're beginning to see some of that work out. For example, California still has the largest number of people on death row in the United States by far. And yet, advocacy over the years has greatly reduced the number of people on death row here. And more recently, even as people's death sentences are being converted to life without the possibility of parole, life without the possibility of parole sentences now nonetheless afford a person an opportunity to go before the parole board and ask for a reduction in their sentence.
Mhm.
A remarkable turn of event if you think about California as the origin of the three strikes law that put so many people into prison for the rest of their lives. Starting in the 1990s, we've really had some major success. And I think part of that success, certainly not all of it, but part of it is work in capital cases that has forced the system to reconsider choices as it made in the most extreme instances, and then recognizing that maybe some of those were mistakes has brought about a willingness to rethink other cases as well.
Is the mechanism of action that you publicize the cases so that it humanizes your client more, and then the everyday person sees that humanization, they think differently, and they elect prosecutors are more progressive, or they like when they serve on juries, they think more progressively. Like, is that the idea to create like that mechanism?
I mean, that is the way it often works out. I mean, whether to seek attention in any particular case in any particular moment is a question not about how I want to bring about systemic change, but a question about whether that'll benefit my client.
Okay.
That being said, when there are significant wins, and any win in any capital case, counts as significant, at least in my book, there tends to be some media coverage, and there are other people doing thoughtful work about how our criminal legal system operates, whether that's journalists or academics or others. But, my lane is more just client centered.
Okay. Yeah.
But the mechanism, of action, as you put it, yeah, is that somebody's going to be reporting on X, Y, or Z, and it does bring about some recognition through that reporting.
Like when you're like outside of the courtroom in your everyday life and you're walking around, you talk to people about like the death penalty work that you do. Like, have you seen like over the years that the perception changes over time? Like, what is like the public perception?
Mm-hmm. Yeah, I think it is important to try to talk to people in everyday conversation about even the complicated points of the way our legal system works, because I think even allies, quote unquote allies, whatever that might mean, may have some misconceptions about it. Whether that's changed over time, I mean, I do think that there has been a shift towards a recognition that we don't need to give up on people, that we don't need to lock people away for forever or kill them. I think that that shift has come through slow, careful work of highlighting the excesses of the way our criminal legal system operates, and through just having conversations about it. I mean, you never know how a conversation about like a small bit of humanity of your client may affect somebody, and people are often at least intrigued, even if they're as excited about imposing the death penalty as possible. I think they are interested in the way the system operates, and it's an opportunity to talk about the way it dysfunctions as well.
Yeah, that makes sense. So what like it's the law firm is a nonprofit structure? Like,
Yes.
do you have like a donor base? Do you have like grants that you write? Like, how does the funding work for it?
Yeah, so Phillips Black is a nonprofit. We don't have a large donor base really at all. We've made most of our revenue comes through court appointments. So I mentioned earlier that if you're facing execution, you're generally entitled to representation under state or federal statute, and so those statutes will also provide some amount of funding for it. It's really different levels of funding in different states. And so one way we're able to do cases in very low funding places is by doing cases where the cases are better funded. Robbing Peter to pay Paul might not be the exact right metaphor, but let's get the idea. We were the recipient of a significant grant to look at wrongful convictions in Philadelphia. But that was under the Biden administration, and it was among the grants that the Trump administration canceled. So we thought we had several years left on it, and that disappeared basically overnight, which was a very disheartening outcome, of course. But, we do have a handful of grants, but the, bread and butter of our work is doing direct representation in state and federal courts. And although in some places it is very woefully underfunded, we've, tried to find ways to make it work. I think a potential area for growth for us as an organization is to think about developing a donor base and identifying grantors other than the Trump administration to provide support.
Like, are there a lot of like nonprofits or law firms that are funded by donors? Is there like a system of that out there?
I mean, there's the Innocence Network, which is affiliated loosely with the Innocence Project. I think it does draw a fairly large number of individual donors, for an example. And I guess I haven't looked deeply into the fundraising operations of other similar organizations, but I think people are increasingly interested in bringing about reform to the way crime and punishment is administered in the United States. And we'll see some. Despite not even asking, folks will make donations from time to time when they hear about our work, and that will free us up to do unfunded work that would otherwise we'd have to decline. And, it has been quite impactful at times for our clients, and, for example, we represent who was the only person serving life without parole for a juvenile offense in North Dakota. That's a client who is not entitled by statute to a lawyer, but we took on his case in hopes of taking North Dakota off the map as a place where you could get life without parole for a juvenile offense. And while we were representing him, the legislature there passed a law doing away with juvenile life without parole, but the court said that change in law did not apply to our client. So
Oh no.
we stuck with him and were able to develop a strong showing that he had reformed himself and made a life for himself to the best of his ability within the prison, and appeared on his behalf in front of the governor's lawyer and the attorney general, and his sentence was commuted to a parole eligible sentence, 25 to life, which made him immediately eligible for parole. And this fall, we'll be representing him in front of the parole board. And that is a case where we will submit zero bills for $0, and we're only able to do that because of donations that we've received from folks.
Gotcha. So like that's an example of unfunded, and then like the work that you were doing in Philadelphia on the grant, that's another example of like unfunded work that you needed to have a grant for.
Precisely.
Yeah.
Mm-hmm, mm-hmm. And look, even the cases that are funded, are often very much underfunded, and we are paid well below market rate, for our time and efforts. And so, figuring out how to make that work is definitely the business side of the nonprofit is definitely a challenge.
Yeah. So like, what was your path into this kind of work? So you went to Cornell Law School and graduated 2008. Like what happened? Like actually, like before that, like how did you choose the law school to go to, and what happened after?
Yeah, sure. So I became interested in attending law school as a way to bring about some change in the world.
Mhm.
I'll say I was thinking about a divinity school at the same time, and decided my skills would best align with going to law school. And I had a vague sense of, maybe I'll do civil rights work or immigration work or become a public defender. That's sort of where my head was going into law school, or maybe human rights work. And I, did the tours of the law school thing. And one of the things that really stuck out to me about Cornell was that it was smaller than a lot of its peers and a lot of the other schools that I attended. It felt much more like a small liberal arts environment, which was very good for me as an undergrad. And I liked that I was able to meet with professors, even though I had not even accepted, admission at that point. And so I got to sit down in their offices and, really appreciated that environment. I liked and like to this day Ithaca, quite a bit. And then it was similarly comfortable to me coming from a relatively smaller town and really enjoying the college town kind of environment. And so that's part of what attracted me to Cornell. Once in law school, I got involved in the death penalty clinic led by John Bloom and Sherry Johnson, and they became mentors of mine. And the thing that really hooked me about that work were, I guess, a couple of things. Like, one, it's hard to think of a more consequential legal question than whether someone should live or die. And that's, at the heart of every capital case. And then, secondly, the questions, the inputs that go into answering that question are very compelling. What does it mean to be worthy of mercy? What does it mean to have your dignity respected? And what does it mean to value human life are questions inherent to the capital sentencing decision. And the conducting life history investigations, turning over every stone, leaving no rock left unturned, is compelling and is still what I find animating about this work. And so I spent a couple of years effectively in the death penalty clinic in one way or another, and had the good fortune getting a job doing capital post-conviction work right out of law school and working for basically a public defender type organization, the Habeas Corpus Resource Center, that really does among the best state habeas corpus work in the country. And so I kind of continue to sharpen my skills and learn how it's done very well. And then, accidents of personal history come up, from time to time for all of us. My now wife was applying to medical residencies, and I had convinced her to only seek medical residencies in death states, in states that have capital punishment.
Yeah,
And
very
so when she found out she'd be doing her medical residency at Duke, I knew I was moving to North Carolina, and the relevant death penalty organizations were not hiring at that time. And so Cornell again played an important role in my path. I reached out to Professors Bloom and Johnson to let them know about my upcoming move, and they got me involved in a couple of cases and found some work for me to do that was relevant. And I formed a 501c3 in part so that I could qualify for public service loan forgiveness. And through collaborations over time, I developed partnerships with Jenny Merrigan and Joe Perkovich, the co-founders of Phillips Black, and we rebranded my individual law office into to Phillips Black about a dozen years ago, and have continued to focus on capital post conviction. But I think the loan forgiveness point is important. My parents basically discouraged me from going to Cornell because of how expensive it is. I think this may still be the case, but at least when I was there, Cornell was number one in how expensive the law school was, and I think especially for people who do not come from a family of lawyers, it can be hard to appreciate the potential return on investment that reflects. Even if there are strong loan forgiveness programs, the tuition top line itself, I think, is a turnoff in a way that can decrease the diversity of the law school and is a real mark against it. That being said, I had an amazing experience there. I've been incredibly grateful for the mentorships, that I've had over the years, but it is a very pricey enterprise.
And like when you were starting the law firm, the Phillips Black one, like how did you come up with the name, the name of it?
Yeah. So, we didn't want to call ourselves the Justice League or whatever for a few reasons. One of which is we wanted to look like a serious law firm to judges. So when our names are on the top of pleadings, we wanted them to associate us with white shoe law firms, not public defender, let's say. We wanted to honor the legacy of Samuel Phillips, a Solicitor General to 4 presidential administrations during Reconstruction, and also most famously probably represented Homer Plessy in Plessy versus Ferguson, a case he lost, but the dissent in that case would become the basis for Brown versus Board of Education. He also argued and lost the civil rights cases, which was a case before the Supreme Court that was trying to enforce the rule of law during Reconstruction, enforce the rule of law in the South during Reconstruction. And then Hugo Black was the Supreme Court justice who wrote Gideon versus Wainwright and a bunch of other important criminal procedure cases. And he is an interesting character because he was able to be convinced in really important cases that have provided foundational bedrock procedural protections. But he was also a right-wing populist Klans member before he was a member of the Supreme Court. So it's a reminder. The hopeful note, I guess, is that everyone can be persuaded of things, that redemption is possible. But it's also a reminder of who it is in this country who has historically had power. So we landed on Phillips Black in recognition of that history. And Inc. is also a nod to history, Phillips Black Inc. The NAACP's Legal Defense Fund was the group that litigated, of course, Brown versus Board of Education, but also undertook in the middle of the 20th century a campaign to end the death penalty. Obviously, it was not ultimately successful, but we wanted to honor that work. And the fund, the group of NAACP lawyers that did that, called themselves the Inc. Fund. And so we are Phillips Black Inc. So that's how we landed on our name.
That's beautiful. And for the closing question, I always ask the guests, what's the kindest thing anyone's ever done for you?
That's a tough one to answer. There's so many beautiful kindnesses I've been fortunate enough to experience. I guess I'll choose a relatively recent one that just filled my heart with joy, which is I have 3 kids, the youngest of whom is 5, but she was probably 4 at the time. And I think I had probably just gotten some bad news, from some court or whatever, and seemed pretty upset. And she, sensing that, just came over and gave me a hug and told me it was going to be all right, And, to see her be so empathetic and loving just brought me great joy. And I hope that Yeah, I love that question because I do hope that we can all be kind to each other, even in the worst of circumstances. And I've tried to, orient my law practice around that idea.
Thanks so much for sharing,
Yeah.
John.
Yeah. Thank you.